Okay, so it says, in addition to other grounds for excluding a criminal responsibility provided for in this statute, a person shall not be criminally responsible if, at the time of that person's conduct, if at the time of that person's conduct, the person was suffering from a mental disease or defect that destroys that person's capacity to appreciate the unlawfulness or nature of his or her conduct, or their capacity to control his or her conduct to conform to the requirements of the law. So there are two elements there. So one, you have a mental disease, you have a mental defect, okay? But more importantly, that mental disease or mental defect has destroyed your capacity. You're not able to appreciate what you're doing, or you appreciate what you're doing, but you do not have the capacity to control yourself. So you almost are suffering from automatism, as it were. So you cannot control your conduct. You cannot ensure that you prevent yourself from doing the things that are not supposed to be done under international criminal law. So insanity as a defense has arisen in only very rarely, it's very rare, in the case of law of major war prosecutions. So for example, in the Rodolph case, it was unsuccessfully raised at the Nuremberg, and I'd like you to look at it and see how what arguments were given and why it was not actually successful. Now, Article 31 echoes McNaughton rules. Remember McNaughton rules in first year? So, you suffer from a mental instability, a mental need that affects your ability to know what you're doing, or to appreciate the nature of what you're doing. So McNaughton rules are derived from the common law. So ICC, Rome Statute really reflects the same. So an individual who succeeds with a plea of insanity is entitled really to a declaration that he or she is not criminally responsible in relation to what they are accused to have done. The second one is intoxication. Intoxication is a very tricky one, okay? Now in sub-article B, it talks about the person intoxication. So I'll start reading from up here at B. So you're not criminally responsible if that person, starting from here, is in a state of intoxication that destroys that person's capacity to appreciate the unlawfulness or nature of his or her conduct, or capacity to control his or her conduct to conform to the requirements of law. So that generally is a reflection of the same arguments that are there under insanity. So you do not appreciate what you're doing, you don't appreciate that it is unlawful, you don't appreciate the nature of what you're doing, or you do not you appreciate what you're doing, but you're not able to stop yourself to control your conduct to conform to the requirements of the law. So that is a reflection. However, there's this other additional point which says, unless the person has become voluntarily intoxicated under such circumstances that the person knew or disregarded the risk that as a result of the intoxication, he or she was likely to engage in conduct constituting a crime within the jurisdiction of the court. So in other words, so you cannot go and say, and you know how this happens sometimes, that sometimes you want to give yourself the strength, quote unquote, to be able to actually engage in the act that is not allowed. So you go and take a little bit of, or a lot of toxic substances, and the whole idea is so that you can get the strength to be able to engage in that illegal act. So if at the time that you actually engage, you're actually getting intoxicated, you knew what you're doing, or you're getting intoxicated with the aim of actually committing an offense, then this particular defense will not then apply to you, because it is only in situations where a person becomes involuntarily intoxicated, and the intoxication is not as a result. Okay, sorry, you can become voluntarily intoxicated. However, the idea is not so that you can get the strength to go and actually commit any criminal activities. Now, the Rome Statute admits the defense of intoxication if it has destroyed the accused person's capacity to appreciate the unlawfulness or the nature of his or her conduct, or the capacity to control his or her conduct to conform to the requirements of the law. Okay, and like I said, the defense cannot be invoked if the person becomes voluntarily intoxicated, knowing the likelihood that he or she will engage in such a terrible crime. Yes, Moses Ali, I see your hand.
Mwalimu, are you therefore saying that if you get intoxicated, of course, with no intention of committing a crime thereafter, but then after you are intoxicated, you find yourself committing a crime, then you can get away with it?
That's what the Rome Statute actually provides. If the intoxication is such a nature, such a huge nature that you could not, of course, it's very difficult to show this, that you do not know what you're doing, okay, or you do not understand the nature of what you're doing, or you don't have the capacity to control yourself. So yes, it will be a defense. If you did not, like I said, if you did not go and become voluntarily intoxicated. So the Rome Statute actually provides for that as a general defense. I think it is more, I don't, what does domestic law provide? Intoxication? I think it's a little bit more liberal than domestic law is. So yes, it's a defense.
I'm getting confused somewhere. Sorry for all this, but I'm getting confused somewhere. Are you saying that if you voluntarily get intoxicated, assume you leave here, leave my house, go take some alcohol voluntarily, of course, with no intention of committing a crime. But then after I am drunk, which I went to voluntarily, then I commit a crime, then I can argue that I was intoxicated. I didn't know what I was doing. Unless someone can prove that I planned this prior to me getting intoxicated. Is that what you're saying?
That's what I am saying, Moses. You find it ridiculous?
Yeah, somehow okay, it's not ridiculous as such. I don't know where I was getting mixed up. At the same time, I felt you were saying that, the bit of voluntarily going to get intoxicated and
so the bit of voluntary intoxication, I was saying that if you voluntarily get intoxicated with the aim of committing an offense, okay, or knowing that you could likely commit an offense, okay. So for example, there's a genocide that is taking place, there's war that's taking place at a particular time, and then you say, let me go and drink so that I can go and hit this individual, kill him, okay, then that is not a defense. Okay, but if you just, there was no intention at all, there was no foreknowledge at all, you just got intoxicated, and then out of it, you then lost control of your faculties, then it can be a defense. Are you together, Moses?
Sure. Now it's clear.
Okay. The next one is self-defense. Now, I'm starting to read from here. The statute provides that the person, okay, someone can be, a defense is if a person acts in a very reasonable way to defend himself or herself or another person, or in the case of war crimes, property, which is essential for the survival of a person or another person, or property, which is essential for accomplishing a military mission, in the case of war crimes only, against imminent and unlawful use of force in a manner proportionate to the degree of danger to the person or the other person or property protected. So the fact that the person was involved in a defensive operation conducted by forces shall not in itself constitute a ground for excluding criminal responsibility under this paragraph. So here you're saying that either your life was in danger, the life of another individual was in danger, and the action that you took were in order to defend yourself or the other person. Or if you have a charge of war crimes, you can say, remember in war crimes, you're allowed to actually, remember you're actually allowed to execute, to use force in a legal way. So if you do it to protect property that is essential for the survival of the person, or property that is essential for a military mission, okay, then you can use that as a defense. Now, the right to defend oneself against an attacker is a basic right of every individual. It's also a basic right of every country. So if you look at Article 51 of the UN Charter, states have the right to use armed forces in self-defense. And therefore, if you conflate that even to the individual, then definitely even the individual has a right to defend themselves. Article 31C, however, says the fact that the person involved in a defensive operation conducted by force, the fact that the person is involved in a defensive operation conducted by forces shall not in itself constitute a ground for excluding criminal responsibility. So the fact that there was actually a legal, quote unquote, a legal war that was taking place, legal armed conflict that was taking place, okay, and then you go out of your way and you then commit a war crime, okay, then that is not by itself a defense, and by saying that, you know, all these things. But the fact that you are doing it to protect your life or your property, that's fine. Okay. Now, it must be proportionate self-defense, proportionate self-defense, okay, it's proportionate to the attack, okay, that is coming, defending yourself, you're trying to defend others, and there must be imminent. So these are the keywords. So first, the amount of force that you've used is proportionate to the amount of danger that is facing you. So as PLO starts saying, you cannot react to a mosquito bite using a hammer. So you must be proportionate. Then secondly, more importantly, it must be imminent. Okay. The force that is coming against you must be imminent, almost about to hit you. Then thirdly, it must be unlawful. So if it is lawful use of force, then of course you cannot then come and react and say that I was defending myself. So the dangerous situation must exist objectively. So in other words, any other individual looking at it should look at the circumstances and be able to say that indeed there was actually imminent danger. Indeed, there was unlawful use of force, okay? And indeed, that the amount of force that you've used is proportionate. So here, we're talking about force, physical coercion, could be psychological threats. It should be imminent. I've already said this, it must be immediately before, it must be exercised, or it must be enduring. What? The force must be there. Was just about to take place, was taking place, okay, at the time that I retaliated or at the time that I hit back, okay? Now, before antecedent, it has not happened, means that sometimes preemptive strikes are allowed, okay, if you really think objectively that something is going to actually harm you, sorry. Unlawful use of force, no right to defend oneself against someone who is acting lawfully. And the whole idea is to save yourself, save your integrity, your physical integrity, your body, or, you know, save your liberty, or to save a third party. Defense of property only applicable to war crimes. Okay, so in relation to genocide, in relation to crimes against humanity, you cannot use that as an argument. Okay, however, why is it there in war crimes? War crimes, because remember, during war, okay, remember what you said, you're allowed to actually use force. So if that property is essential for your survival, is essential for your military mission, then you can then use it because it's part of what is being allowed. The defense must be reasonable, the defense must be necessary, the defense must be proportionate. Okay, and IHL, I think I hope you're all going to do IHL next semester, because it's really got a lot to do with the war crimes and use of force. And I hope all of you are also following I hope you follow the submissions by South Africa in the ICJ in relation to the charge of genocide against Israel. I think for students of ICL, I think what is going to come out of that court will be very, very interesting. However, self-defense cannot be used to excuse a deliberate attack upon a civilian population. The property defended must be essential for the survivor. I think I've already mentioned that. The next one, the next defense is that you can be used. You're not criminally responsible if, sorry, yes, Chelsea?
Sorry to take you back, sir, but I have a question in regards to intoxication, specifically voluntary intoxication. And my question is, what is the test for voluntary intoxication? When someone goes to court and says that the defendant or the other side was voluntarily intoxicated, what is the test? What must they do to prove that? Seeing that maybe only the defendant in question might the one who might be privy to that information.
I'm trying to understand your question. So what are the elements to be shown to show that there is voluntary intoxication?
Yes, something along those lines.
Yeah, so this is really, the evidence is really depends on, it's really very circumstantial, should I put it that way? Really depends on what they had the individual say, what they had the individual claim. Maybe they were boasting and saying, this is what I want to do so that I can actually perform this act. So it really depends a lot on the circumstances that are there. It's very circumstantial. So it's you cannot, of course, get into the mind of that individual to know what they were doing, whether they were doing it intentionally to commit an offense. But depends on the circumstances that are there. If they actually point in that particular direction, then you can then say, and especially I'd say objectively, where you have a situation where you have, say, crimes against humanity that are taking place or genocide, and you then have a situation where someone, the perpetrator, how should I call it? The perpetrator group, an individual from the perpetrator group has killed someone from the victim group, okay? Then you can always say that the assumption is, of course, that they did it intentionally. I think the burden is now on that particular individual to show that although they got intoxicated, it was not with an intention to actually commit the offense. So it's very circumstantial, to be very honest with you. Okay? Then the next one is duress or necessity. Again, blah, 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 Article 31. Another ground for excluding criminal responsibility, if you look at D, the fourth one, the conduct which is alleged to constitute a crime within the jurisdiction of the court has been caused by duress. Okay? Duress. So what is that? Where you have a threat of imminent death or a threat of continuing or imminent serious bodily harm. Sorry, people, there's some construction. I apologize for that. A threat of imminent death or a threat of continuing or imminent serious bodily harm against that person or another person, and the person acts necessarily and reasonably to avoid this threat, provided that the person does not intend to cause a greater harm than the one sought to be avoided. So such a threat may either be made by other persons or constituted by other circumstances beyond that person's control. So, for example, you would say, Your Honor, I'm just using this as an example of duress. So where someone comes and says, I was forced to do this. If I had refused to do it, I would have been killed together with the victims. When I refused, they told me, quote, if you are sorry for them, stand up, line up with them, and we'll kill you too. I'm not sorry for myself, but for my family, my wife, and son, who then had 9 months. And I could not refuse because then they would have killed me. Okay, so you're saying that you really didn't have a choice. The choice that you had was no choice at all, because your family, someone close to you was in danger, your life was in danger, and so you had to do what you had to do to protect your life. So in Prosecutor versus Edramovich, this is ICTY, they said that duress does not afford a complete defense to a soldier charged with a crime against humanity and a war crime, and/or a war crime involving the killing of innocent human beings. So in other words, here they're saying that in the ICCY, they are saying that, look, even though you are doing what you needed to do, even though your life was in danger, you were in danger of suffering bodily harm, the idea is there are also other innocent people who have died. So we are not going to allow you to use it as a defense, but we can use it as during mitigation. If you get convicted and when you're sentencing you, we can consider that fact. Okay, so the application was that we could consider it, okay, but we cannot then use it to get out, to escape liability. So the ingredients are this: there's a threat of imminent death, A, or B, there's continuing or imminent serious bodily harm, okay, C, against that individual, the defendant, or against a third party made by other persons or by circumstances beyond that person's control. Okay, and then secondly, what you then did in reaction was necessary, it was reasonable to avoid this threat. It is what someone will then look at and then say, okay, fine, fair enough. In a similar situation, I would have done the same. On the subjective level, the corresponding intent, you're not intending to cause a greater harm than the one that is sought to be avoided. So again, proportionality is also very important. So if they say they're going to take your money, okay, or they're going to destroy your car or something, I don't know, just something minor, that's not good enough, I guess, to kill people, innocent people. But if they say they're going to take your life away, then I mean, it must be imminent and it must be proportionate. Necessity. These are situations where the actor's freedom of will, the actor's ability to make decisions are limited, such that the attribution of certain criminal results would appear unjust. So a person acting under duress, remember it's duress and necessity, is someone who is compelled to commit the crime by a threat or to his life or that of another person. In the related defense of necessity, this inexorable threat is a result of natural circumstances rather than that of other persons. But in either case, the defendant is deemed to have no viable moral choice. So in other words, in duress, someone is forcing you to do it. In necessity, it's circumstances of life. Things that just happen in such a way that you have to commit the offense. I don't know. I'm trying to think of a situation where maybe there's flooding or something and you have to defend yourself. And to defend yourself, you have to, I'm trying to think, maybe there's a storm and you have to throw other people out to be able to defend yourself, something to that extent, yeah, in that line. So essentially, it's really nature, but in duress, it is someone who is forcing you to commit the offense. So the ingredients, there must be an immediate threat of severe and irreparable harm to life or limbs or property or your body. 2, there is no adequate means of averting such evil. 3, the defense was not disproportionate to the evil threatened. It's a lesser of 2 evils. Then 4, the duress situation was not voluntarily brought about by the person who has been coerced. So immediate threat, so you can see it coming, or it's already upon you, so you've been warned this is what is going to happen to you, or you're being told that this is actually happening to you right now or to your family members, and you try and think of other ways of getting out of it, you are not able to, and that's a list that you could do then. You say, okay, fine, I'm going to get involved in this criminal act. The duress situation was not voluntarily brought about by the person. So you did not join a gang, for example, that is committing these offenses, and then you are pushed to the corner, okay, knowingly. So you do not bring it upon yourself. You're just perhaps just passerby or something like that. The next one is mistake of fact and mistake of law. Article 32 of the, is it Article 32? Yeah, I think it's Article 32 of the Rome Statute. So generally we say ignorance of the law is no excuse. However, in some situations, your ignorance could actually have taken away your mens rea. So generally, a mistake of fact is generally excusable. However, mistake of law is not excusable. So you do not know the effect of your action. That's wrong. Sorry, that's not good enough. So I killed that person. I did not know that killing that person is wrong and that I'll be imprisoned. Okay, that's not excusable. However, it could be a mistake of fact. I killed that person thinking that he was a dog. Okay, so I made a mistake, hit him. Or I thought it was a snake that was coming into my house. So I took a djembe and a club and hit and killed him. Okay, so the mistake is that I did not know that it was a human being. So that is excusable. So there was no mens rea at that particular time. So a mistake of either type can be relevant only if it negates the mental element of mens rea. Okay, so e.g., a soldier who confuses the civilian standing in front of him with a combatant and shoots him. Okay, so that's a mistake that is, you could say it's excusable. So it's in a situation where there's armed conflict and you're allowed to engage with combatants and you thought that this individual was a combatant. So you shoot him, that's fine. Okay, but what if the soldier kills civilian A, confusing him with civilian B, who he actually wanted to kill to settle all scores? So again, we have a mistake, but it's a different kind of a mistake. Okay, this is a mistake where there is mens rea. Okay, you actually intended to kill a civilian, only that your mistake was in killing the wrong kind of civilian. Okay, so there, that's not excusable. Okay, so the mens rea is already there. If the soldier correctly identifies the person standing close to him as a civilian, but wrongfully assumes that the law allows him to shoot even civilians during an armed conflict, what about that? Class. So there are three mistakes here. One, the first mistake is, I'm giving you examples in a situation. A soldier kills a civilian. He thinks that that civilian is a combatant, is a soldier, and then he shoots him. That's one situation. Another situation is the soldier kills civilian A, knowing that he wants to kill civilian B. Okay, his intention was not to kill civilian A, his intention was to kill civilian B. And he knew, okay, that this particular civilian that he killed is, the intention was to kill a civilian. That's B. C, a soldier correctly identifies the person standing close to him as a civilian, but wrongfully assumes that the law allows him to shoot even civilians during an armed conflict. Okay, so are you seeing those different types of, should I say, ignorance of fact, mistake of fact? So in the first one, it's a mistake that does not give him mens rea. It's excusable. The second one, there is mens rea to kill a civilian, only that you got targeted and got the wrong civilian. So not excusable. The third one is, again, there's mens rea to kill a civilian, only that you do not know the legal consequences of your actions. Okay? So again, the third one, not excusable. In the Thomas Lubanga case, Lubanga was charged with the war crime of Thomas Lubanga, I'm sure you know, is in DRC, was someone who was charged in the ICC. He was charged with the war crime of enlisting and conscripting children. His argument was that he could not have known of the prohibition of the relevant acts since neither Uganda nor the Congo brought to the knowledge of the inhabitants of Ituri, where he was, the fact that the Rome Statute had been ratified. Okay, so in other words, he's saying it's a mistake of law. I did not know. Ignorance of the law. Okay, and here the court said that all this is irrelevant. The next one is an interesting one. It's called superior orders. So generally, soldiers are trained not to question orders, but to follow them. So you're supposed to move when you're told to move. You're supposed to stop when you're told to stop. You're supposed to run when you're told to run. And the psyche of a soldier is really to obey the orders of the superior at all times. The problem now comes in ICL when you're told to actually commit an offense and you commit the offense, and then later on you come and say that, look, I did not do it intentionally. I was following the orders of my superior. So that is what was found. That was what was there in the Nuremberg trials. So most of them came and said, look, it was not us. We were under orders. So sometimes, however, there are situations where if you disobey, there could be disciplinary sanctions. And some of these sanctions could include the death penalty. However, on the other hand, if you obey, then you're committing an international crime and you're likely to be prosecuted and taken to jail. Okay, so how does the law balance all these situations? The statute, IMT statute, said that the fact that the defendant acted pursuant to orders of his or her government or of a superior shall not free him from responsibility, but may be considered in mitigation of punishment if the tribunal determines that justice so requires. So they were saying that, look, that's not a defense. It is something that you can use when you have been convicted and then use it in mitigation so that we can reduce your sentence. However, it is not a defense so that you escape criminal liability. The argument was this, that the obedience of a soldier is not the obedience of an automaton, a machine. A soldier is a reasoning agent. He does not respond and is expected to respond like a piece of machinery. The fact that soldiers may not, without incurring unfavorable consequences, refuse to drill, refuse to salute, refuse to exercise, recontour, I don't know what that means, and even go into battle, does not mean that he must fulfill every demand put to him. The subordinate is bound only to obey the lawful orders of his superior. And if he accepts a criminal order and executes it with malice of his own, he may not plead superior orders in mitigation of his offense. So in other words, they are saying you cannot follow the criminal orders of your superior and then come and argue that you are under superior orders. However, the ICC seems to have given a little bit of an leeway in relation to superior orders. And these are the three conditions. There are three conditions, however, that are there. So the first one is, first you must show that the accused must be under a legal obligation to obey the orders. Okay, so first of all, we're talking about orders. At the time of the attack, you were legally obligated to obey the orders. The orders are not coming from a criminal organization. So we're talking about a military situation, okay, where you have orders. There is a hierarchy. And based on that hierarchy, you're supposed to follow the orders of the hierarchy. Okay. However, thirdly, the orders of a civilian must, now, this is where it gets interesting. So in a military situation, it's very, very easy to show that you are under a legal obligation to obey. The concern usually comes in when you're talking about civilians who are exercising control over their subordinates, okay? And you then, in that particular situation, you must show that what you had was a structure that was almost military-like, because you cannot come and say that this man was my boss. In an army, yeah, perhaps, but in a civilian, you must show that that civilian had a degree of control over the subordinates, and that was similar to the one that is there in a military. So essentially, that's part of it. So one, you must be under legal obligation. Okay, so this is what legal obligation means. So it must be at the time of the attack. Legal obligation means that it must be it must be a military organization. Okay, legal obligation means that the person giving the orders must be a military commander. Okay, not a civilian commander. Two, the second one, the accused must not know that the order was unlawful at the time that he did it, that he followed it. So, e.g., a soldier who kills a civilian on the basis of an order that he believes to be lawful. Okay, so you must, at the time, you did not know that the order that was given was unlawful. And then thirdly, the order must not be manifestly unlawful. So there are some orders. So you might say, I do not know. But there are some things that you cannot say, I do not know too, because they are manifestly unlawful. They are obvious. They are self-evident. It is incontestable that everybody should know this, even a child. So for example, an order to commit genocide, an order to commit a crime against humanity. Okay, all these are seen to be manifestly unlawful, and so you cannot plead superior orders. So let me take you, the distinguishing mark of a manifestly unlawful order. Let me just describe that a little bit more. The distinguishing mark of a manifestly unlawful order should fly like a black flag above the order given as a warning, saying prohibited. Not formal unlawfulness, hidden or half hidden. No, unlawfulness discernible only to the eyes of legal expert is important here. What you're concerned about is a flagrant and manifest breach of the law, definite and necessary unlawfulness appearing on the face of the order itself, the clearly criminal character of the acts ordered to be done, the unlawfulness that is piercing the eye and is revolting to the heart. Be the eye not blind, nor the heart not stony and corrupt. That is the measure of manifest unlawfulness required to release a soldier from the duty of obedience upon him and make him criminally responsible for his acts. So here we're talking about things that are obvious. So it's a very nice, I think I liked it, a very nice statement by Judge on what a manifestly unlawful order is. Okay, it's something that is so obvious that anyone looking at it will say, oh, come on, you cannot obey that order. Oh, come on, that is obviously a criminal. Oh, come on, that is obviously wrong, illegal. And so to that extent, then, you're then, as a soldier, then you cannot then now go out and plead superior orders. You're stopped from that. Okay, so if you have to go back on superior orders, okay, it's very important to see that yes, it is allowed, but with conditions. And these are the conditions. It must be manifestly unlawful. Sorry, these are the conditions. You must be under a legal obligation. So you are coming in from the military. Okay. Like we said, for civilian cases, it must be a situation where you have a civilian hierarchy, a hierarchy that resembles the military kind of hierarchy. So you're not talking about some situations, for example, the president tells you to do something, okay? So that you could argue that is not really the same as what is there in a military. In a military, there's a strong control over the subordinates. If the president tells you to do something, there's the option of resigning. Okay, he does not have that kind of control that the military has. Anyway, so one, you must be in an organization that has that kind of control. Two, you must not know that the order was unlawful. You didn't know. Three, the order was not manifestly unlawful. Those are the three requirements. Now, perhaps I should have mentioned this at the very beginning. It's also important for you to note in your reading that sometimes some of the things that I am saying could conflict with some of the decisions that have been passed by other tribunals. Okay, remember what I'm giving you are what is there in the Rome Statute. In other words, what the ICC is going to be using. Okay, remember other tribunals that came before the ICC was established, okay, had their own standards. Okay, I wish we could actually have had the time to actually go through each of them to see how each of them interpreted each of these defenses. Okay, but unfortunately we don't have that time. But it would be interesting for you. It's something you can look at. How did the ICTY look at this superior orders? How did the ICTR look at superior orders? Okay, of course they're influencing each other, but remember they are independent courts. So it's not like we have the Court of Appeal and the High Court that has to follow the orders of the High Court. They're all independent. So they influence each other, but they can conflict. So, however, what I'm giving you is what is there in the Rome Statute. Consent of the victim, so volentin and fit injuria. So a person is not wronged when he or she consents to the crime. So if the consenting victim is entitled to dispose exclusively of their legal interests protected by the offense or the offenses concerned. So you as an individual, you have allowed yourself to get involved in that. However, remember, consent in some situations is no consent at all. So in a situation of war, you cannot say when someone is charged with a sexual crime that there was consent. In that situation, there cannot be any consent between the perpetrator and the victim to any sexual acts. Okay. So, for example, when you had the post-election violence, there are a lot of women who are raped in Mathare and Kibera, the slums. Okay. Now, you cannot use, even if the individual said yes, that is not a consent at all. I'm sure you understand what I'm trying to say. That the circumstances, the environment did not allow for consent to be given. So it's not a true voluntary consent. Okay, so here in Kunarach, they said the circumstances are important. That prevail in most cases charged as either war crimes or crimes against humanity will most likely be almost universally coercive. That is to say, true consent in those situations will not be possible. Military necessity. Okay, so sometimes what you did is part of your military necessity. So in those particular situations where it's not justified by military necessity, then you can use it as a defense. Okay, so I think that's generally it. Remember, these are not the only defenses. These are the defenses per the Rome Statute. Okay, and I wanted us to go through them so that you can just have a basic understanding of the general defenses that can be used whenever you have a situation when someone is charged in court. Any questions so far? Any question from anyone? Okay, I think let's stop there. I'd encourage you to do a little bit of more reading individually so that you can get the details. Now, something else that I'd like us to look at, which is a very last bit, is on transitional justice. Transitional justice is, I think, is something we are all interested in terms of what is the right way to go whenever there's a situation of after conflict has taken place. What is the right step to take? And it has been, I don't have the answers, and I'm putting it here because I really don't have any answers to it, but it is interesting, and it really depends on, there's a lot of politics that's involved, there's a lot of subjectivity that is involved, but it's interesting to see in terms of what have other countries done and how has that helped them or not helped them. Yes, Washington, I see your hand.
Yes, Happy New Year, Mwalimu.
To you.
Yes, in relation to what we've discussed, can I presume that in the conflict between Israel and the Hamas, their proper defense would be that they were targeting Hamas, who are hiding behind the citizens. And in that, what specific defense would Israel rely on the examples you've given us? Thank you.
Yeah, the main one would be military necessity, that you're in a situation of armed conflict, and in that particular situation of armed conflict, you're allowed to use force, reasonable force, that is in order to defeat the enemy, and you are then doing it for purposes of defending your country and defending your people. Now the question is, I think what people are not, the argument is not really on whether Israel is could actually have got in and did the things that they did. The question is whether the force they have used is reasonable and proportionate to the harm that they suffered. And so if you go in and you start bombing hospitals and you know, those kind of things, then and civilian, where civilians live, then of course you are then now going a little bit more than, you know, you're now getting into what you call war crimes. Okay, now South Africa says that they're now actually committing genocide against the Palestine people. Perhaps not genocide, maybe it's just war crimes. So the defense is that it was military necessity. They had to do it in order to defend their people. The other argument they make is that Hamas is not really an armed, it's not really a, how shall I put it? It's a terrorist group. Okay, some people will call them freedom fighters, but it's a terrorist group according to Israel. And so these are not people who come and face you using the normal style, normal ways of combat. So they are using of armed conflict, of combat. So they're using unique ways. So it's a terrorist organization. So they go in and hide in hospitals. They go in and hide in amongst the people, the civilian people. And so when you actually are bombing these civilian residences, the reason why we are doing that is because we know that Hamas has an area there in the hospital where they actually have their armed where they're keeping their arms, the place in the hospital where they're using it as a location for discussion and for all those things as a source. So that's the argument that Israel is making. Whether it's reasonable or not, I think let's hear what these judges will say. I think it's a little bit extreme though. Are you together, Washington?
Yes, we are together on the reason on the what we call the weight of reason, what we call the weight of being reasonable will be measured upon certain weights, I believe. What weights do you think would be used? Because looking at certain weights, let me give an example of certain weights. We can use the weights of Bill Clinton, then the Nagasaki war. That was not even a war, Nagasaki bombing. Would we use that as an example of a weight? And if that is not the required weight to respond to certain things, then as much as so many people still believe that Israel is using a lot of muscles compared to other countries who've used certain muscles. They've done the killings, yes, but compared, if we start using the weights, we could find that the weights they've put down are not exceeding the previous weights. Because these weights, these reasonable weights will be measured against something. There must be something that is used as a precedence in reasonable weights, and checking on the history of what has been used as reasonable weights. There are so much behind reasonable weights. Yes.
Yeah.
That is what I think.
I like that, and I'll open it up for the class to give their views also. I like what you're saying, that remember there's a weight, there's World War II, there's a Nagasaki, there's a bombing that took place, the nuclear bombing, and you know what it actually did to that country, and you know what it did to humanity as a whole. But the question is, was it reasonable for the US to, its allied forces, to actually drop that bomb? Okay, now of course there are people who say no, because in any event, Hitler at that particular time was on the reverse, was on the not reverse, was what's the word I'm looking for? They were not advancing anymore. They were actually going backwards. So did they have to do that? Other people argue that if they did not engage in that particular kind of warfare, then more people would have been killed. So yes, maybe the Europeans were receding, the Germans were receding, but what about the Japanese? Is it the Japanese? Yeah, the Japanese, were they not continuing and all that? More people would have been killed than the ones who were killed by the bomb. So it's very subjective, I think. It's I would say in Israel's situation, of course, the weight is there. I would measure it. I'd look at it in terms of the number of people who have been killed, the Israelis, the number of people who have been what's the word? The number of people who have been displaced vis-a-vis the number of people, Palestine, from the Palestine nation, who have been killed and who have been displaced. So I look at it in terms of numbers of people. So if you're looking at 10 Jews, do we have 10 Palestinians killed? And that would be like, perhaps it's fairly okay. But now if you have a situation where you have 1,000 Palestinians who have been displaced, is it 1,000 or something like that? I don't have the numbers yet, but it looks like it's a little bit off. It's too much, I think. That's my view. Okay.
Can I contribute?
Who is that?
Can I contribute? Yes.
Yeah, please
yes,
do. Definitely, please do.
Thank you very much. the history of the 50-year history that's of the conflict here, which Netanyahu also alluded to, the probably done to Palestinians. I mean, it repeats itself, and I see it's repeating itself, but because of the knowledge, for example, of the what happened in Cambodia. Now, the target here is, from my thinking, is not necessarily the Hamas. The target is those children to decimate the population, that you do not have people who would recall what the Israelis are doing. You do not have children who grow up to form a formidable force against Israel. And, by the time you have a critical number of people who can bear children who will be able to have a military might, that's going to be another, like 50 or so years, because you're not going to eliminate all of them, the children, the Palestinian children. And the cycle, when you look at it, is that, yes, they went into Gaza. The initial reactions, those ones were militarily justified. But the planning, if you read the history, even why they have not gone into after the Hamas initially, was basically because of these knowledge that they will be committing war crimes. So that was there, and that had been actually discussed within the cabinet, with even divisions amongst his members, that we can't do this because of the consequences. So by going in this time, they knew very well that yes, we have responded, but by continuing with the process, it is already something that had been, it was in the planning. So it is, you'd call it, if I would agree with the South Africans, I would call it genocide, because I see displacement, I see killing, I see, uprooting, making sure that there'll be no children to form a force within the next 50 or so years. Now, having said that, does Israel, yes, the military, was it military, does it have a military necessity to have acted the way they did? And if you look at even the US, at one time they said, no, I think now it's, if you are crossing the red line. So those warnings have been there. So if I was a judge of the ICC, I would say, yes, you have crossed the red line. And whether you call it genocide, there is definitely crimes here against humanity. So I would probably, even if you don't call it genocide, but the elements are there. So that would be my my verdict based on those.
Thanks, Wanyoike, for that. The cases of the ICJ. Now, what about the argument? There's an argument. Now think about it like in fact, we had the same problem. Kenya is fighting Al-Shabaab in Somalia. And the argument that what would you react to the argument that Israel is giving that, look, Hamas is amongst the civilian population. So you people are saying we're killing the civilians, but Hamas is operating within the civilian population. These same civilians you're trying to support are the same people who are giving them homes, are the same people who are giving them bases through which they can actually attack us. These same hospitals you're looking at are the same places where they have tunnels, and they use that to actually get into our borders. Okay, and they then attack us through those using those hospitals. So we have to, that's where the weapons are actually. Okay, so you might think it's a hospital, but down there underground, it's actually a base of Hamas. So what do? We are supposed to actually, we are fighting a faceless enemy. It's an enemy who does not have uniform, who does not have, we have uniform. You can see that I am a soldier, I am engaging, but this person will come and engage and disappear within the community, in the schools. What am I supposed to do? I have to protect my people. So do I just say that I cannot bomb the population, civilian population, yet I know that Hamas is operating within them? So think about it like Kenya and Al-Shabaab, same problem we had. Someone just comes, is a lady, dressed up with a buibui. Kuba is a member of Al-Shabaab, okay? So what are you supposed to do in that particular situation? And it's, am I just supposed to say, I cannot attack civilians, leave it at that? Yet I know that Hamas is actually operating amongst the civilian population. Koech.
Mwalimu, before Koech, just in to rebut that what you're saying is very true. Because remember, when the United States walked into the Al-Shabaab area, those people, they got slaughtered because of what you're saying. They were trying to take the chaff out of the wheat, and try to separate the Al-Shabaab from the citizens. And the American military soldiers were slaughtered in numbers because of trying to do that, which was sought to be a humane thing. And because of this reason only, Kenya went there, swept, killed innocent Somalis, and up to date, no one has ever risen a voice to that effect because of this first instance that United States suffered together with Uganda. I can also put it that put an addition to what I was saying on the weights, because looking at, for example, Alexander the Great conquest, this is like a conquest. Whatever is happening in the Middle East conquest did not start today, not yesterday. It started all along in the ancient history of the Asians. And looking at the one of the example that I'd give you briefly is you can look at the Battle of Guatemala, considering one of the Alexander's most decisive victories resulted in the estimated number of Persians were 40,000 Persians were casualties, and it has never been seen ever as a genocide recorded for any other reason because of the soldiers' compact. So I support it that you in the war of Israel and Hamas, it's very difficult to differentiate who is now not a soldier and who is a soldier. Just the same way Kenyans killed so many Somalis without any voice of genocide or something in the port of Kismayo. Thank you.
Yeah, thanks, Washington. What about Koech was saying something? You had your hand up.
Mwalimu, am I audible enough?
You're audible.
Thank you. I think we have to put this into context and remember that Hamas is not only just a military wing. They have their military wing, which is the Al-Qassam Brigade, but they are the legitimate government of the people of Palestine. So when you say you are going to war with Hamas, or when the Israelis say that, that means they are going to war with a legitimate elected government of the Palestinian people. Be that as it may, I am a believer of the principle of proportionality, which Israel has been just thumping and saying that they are one of the most advanced militaries in the world, which means that they have access to intelligence mechanisms that many states don't have access to. And they also have quite a huge number of population that are military trained. In fact, their adult population, you have to undergo some military training upon attaining the age of 18. So I believe that Israelis have enough equipment to conduct intelligence and counterintelligence measures to fight the Al-Qassam brigades, that the military wing of the Hamas, and they also have enough boots to go in and attack these particular military targets. You see, the problem with carpet bombing, as has been seen since November the 7th, we have seen many civilians getting caught in the crossfire. Yeah. And yet we understand that one of the main aims that you're supposed, or an aim of a military attack should be on a military establishment, yeah, or a military target. So carpet bombing is inexcusable, and I believe that the Israelis can do much more. They are integrated into the society because they are the government there. So they have to find a better way, not conduct these heinous acts that we are seeing going on.
I'm not a supporter of Israel, but I'm just trying to try and understand their arguments. Because Kangongo, how do you do in a situation where the person you're fighting is actually disappearing within the civilian population, is operating from the civilian population? How do you operate? How do you deal with that situation? How do you deal with that situation?
Mwalimu, remember that it is a technological era. We have drones, for example, the B9 bomber, which can get good surveillance and intelligence. We have technological networks. People use phones nowadays. I understand that the Hamas uses paper and pen to relay messages, but there's always that element of use of technology. So given that the Israelis have, or rather the Jewish people have quite a large sway in the world of tech and finance, they are able to get this intelligence. My question is why they don't want to act upon this intelligence, given that even October 7th was an intelligence failure.
Mwalimu, there's something that my colleague is misleading. Is misleading the class. Allow me.
Let's allow someone else.
Mwalimu, there's something. We will take this as
Washington. Let's allow someone else. Al-Bashir has his hand up. Then
Mwalimu, there's something we cannot. There's some. You know, we are a class of facts without information. Whatever we lay should be facts. I want to put it on record, and someone can challenge this if it's not on record. That Hamas has just been a de facto government body in Gaza Strip since 2007, when they hosted the Palestinian Authority. Underline the word, when they hosted the Palestinian Authority. Just the same way Al-Shabaab hosted the authority in Somali. So please, let's just get our facts straight. These are the same people who acted in Lebanon. So when we're giving our facts, please, let's just be factual.
Okay, thank you, Washington. And let's move to Al-Bashir, and then we'll close it. We're not discussing, we're now moving off a bit. Al-Bashir, floor is yours. You're muted, Al-Bashir. Is Al-Bashir here? Ali Bashir. Okay. I think we've lost, I don't know if he's there. Maybe we can't hear you, Ali Bashir, if you're trying to speak. You can't unmute yourself, sorry. Then type it. And sorry, I'm sorry about that.
Yes, Mwalimu, now I succeeded.
Yes, Ali Bashir, please make it short, please.
Mwalimu, before I give my comments, the last speaker, Washington, said we should challenge him on facts. I want to go on record, and you can also challenge me on facts, that despite Hamas's reputation in many countries as maybe an organization that does things that are associated with terrorists. I don't personally consider them as terrorists because I believe they are a resistance movement. Hamas was an elected government before they were proscribed as a terrorist organization. And then in an election that was overseen by the West, the EU and America and the Arab League. But because they took some positions that were not palatable, then they were proscribed as terrorist organization. Having said that, let me now attempt to answer your question.
Yeah.
Malemu, the fact that before even we speak about Hamas embedding themselves in civilian infrastructure, you look at some of the statements made by the top echelon of the Israeli government, from the president to the prime minister, in the aftermath of the October 7th attack by Hamas, they said the entire population is responsible. And therefore, when they attack a civilian infrastructure like a school or a hospital, they're only, proceeding with just inaction what they have actually said in words. And therefore, it should not be very hard for us as ICL students. But the intent is there. When the Prime Minister quoted a biblical statement of Amalek, where he talks about killing man, woman, including animals and children. And he does that in action by giving instructions to his military, then I don't think it should be very hard to determine whether there was genocide committed. The president said every Palestinian is responsible. And they are attacking UN-run schools and hospitals, not Hamas-run institutions. So in my opinion, I don't, given that now that we have studied about genocide, I see a very clear evidence for that.
Thank you, Al-Bashir. Thank you, Al-Bashir, for that. Actually, maybe we should maybe have just a class for this Hamas Israeli thing. Maybe even have a debate on it, and just because I'm seeing there is a lot of material on it that's related to what we are doing. Perhaps we can organize that sometime after the exams or something like that. Anyway, let me just move on to what we're supposed to be doing, which is restorative justice. After war, what next? Okay, and this is, I was trying to say that this is important because it is up to us. We don't know. There's no answer, really, but we just want to see the different options. So how do you pursue justice after a war has been finally concluded? So, for example, in Sierra Leone, there was a war that began in March 1991, when Foday Sanko's rebel group, the RUF, invaded from Liberia. Sankos, was infamous for amputating the limbs of anyone, even babies, can you imagine that, who seemed to stand in its way to power. When the war concluded 11 years later, you have 75,000 civilians have been killed, 20,000 have been mutilated, 2 million people have been displaced. So you are in the new government. How do you deal with that situation? Okay. Now, there's a Western perspective that says we need to punish the guilty. However, there's also what we call the traditional African jurisprudence that does not really look at punishment of the guilt. It emphasizes on reconciliation, restitution, and restoration, the 3 R's. Reconciliation, restitution, and restoration. So whereas Western jurisprudence is retributive in nature, the African jurisprudence is more of restorative rather than retributive. So we do not want to punish the guilty per se. We want to restore the society to where it was and hopefully then move on from there. It's almost like saying, let bygones be bygones. Let's move on. Whereas Western jurisprudence moves, intends, and pushes for the tribunals that we looked at. However, there's an argument that says that does not make sense. Sierra Leone and Rwanda had that problem. Do you go the retributive way or do you go the restorative way? Now look at the amounts that are spent. In Sierra Leone, they had a Truth and Reconciliation Commission that cost $5 million in total. But the retributive way, Special Court for Sierra Leone, spent $300 million every year. In Rwanda, Rwanda is a beautiful case, and I wish all of you would go and look at what happened after the post-election after the violence, the genocide. The traditional restorative, they established what are called Gashasha courts. They have spent 40 million and they have tried over 2 million cases in a decade. However, the ICTR, which we have studied, look at the price tag, $300 billion every year. Every year, versus $40 million for that entire period, 10 years. $300 million every year. And what is the output? That is a problem. The output is we have 100 cases only. Gashasha, you have 2 million cases. And if you can go to YouTube, go and check how the response that the president has. Why did he go towards the Gashasha courts? Because at some point he said, ICTR does not make sense. And at some point, people say, these tribunals are really, if you're to be very honest enough, just jobs for the boys. It's really about creating jobs. So in Arusha here, we had all that. It created a good economy for Arusha, yes. But at the end of it all, you ask yourself, how many people have been convicted? How much money has been spent? Was it worth it? Why not take that money and give it to that country so that they rebuild the economy? Now, retribution. That's a view that someone who is guilty needs to be punished. And this punishment should be proportional to the seriousness of the transgression. It's just based on the idea that just deserts, someone should be given his own just deserts. There's a need to negate the wrong done. There's a need to reassert the right. The underlying idea is fairness. For fairness to be there, the offender must pay. The offender must be punished. And you see that a lot in courts, even in the news, when someone is convicted, you have a news item where someone has been convicted, and you then talk to the victims, they interview the victims, and you'll hear the victim saying, now we are happy because the person has been convicted. He is going to pay, she is going to pay for her crimes. So that's the retributive bit of transnational, of justice. And the idea is that the international law paradigm obliges. What's the argument? Why do states take at that angle? Because they say that generally states are obliged to investigate, states are obliged to prosecute, states are obliged to punish international crimes. They say that adequate reparation means perpetrators must be brought to account. They must pay for their crimes. They say that accountability is important to prevent future atrocities. So in other words, unless people are punished, it will happen again. So you need to punish people so that let me put it in Kiswahili. Iwe funzo kwako na wengine ambao wenye tabia kama hiyo. Okay? So ili iwe funzo for other people who might be interested in committing similar offenses. Okay? Let's punish these people. Then they talk about Article 4 of the Genocide Convention, Convention Against Torture, that say that there's an international obligation to actually try these people. However, these are the challenges of this, and we if you look at the tribunals we've been looking at, major challenges. One is lack of enforcement mechanisms. Two, limited jurisdictional scope. And if you look at the tribunal you are studying, you're looking at as a group, the jurisdiction was very limited, okay? And it's limited in terms of time, it's limited in terms of the people you can arrest, it's limited in terms of the offenses that they can try. Thirdly, the inability to extradite suspects from non-compliant states. So the tribunals cannot force non-compliant states to extradite. Fourthly, consistent underfunding. Although we are talking about a lot of money being spent, still a lot of underfunding. And why? Because of the people who are coming in. There's so many professions, lawyers, social workers, counselors, all these people, investigators, okay, judges, very many people who want to be paid every month for 5 years or so. Then there's a problem. The biggest problem is this, sluggishness. At the end of it all, when the ICTY is being closed, when the ICTR is being closed, you look at the output and you say, was it worth the amount of money that was spent, the input? Perhaps not. Oh, and also sometimes people say that these are just things just to close our eyes so that we think that justice is being done. But in reality, it's not that justice is being done. Then the last one is the retributive path can be an obstacle to peace for you to move forward. It can be an obstacle to truth. It can be an obstacle to reconciliation. At the end of the day, we need to move forward as a state, as a nation. Think about Rwanda and genocide, and people have been killed. All your landed people have gone, okay? Your systems are down. Are you going to spend time punishing people? Or are you going to spend time looking for peace, looking for truth, looking for reconciliation so that the people can move on, the country can move on, okay? I'll take you back to the documentary that you look at. Remember, at the end, there's a piece where they talked about the Rwanda genocide and how the perpetrators, one of the perpetrators got married to the victim. Okay, the man who was a perpetrator who killed the husband to this lady, okay? Later on, in terms of reconciliation, they went, I think he got married to that lady or his sister, and they then said, we are reconciling and we are moving on, we have forgiven each other, we need to move on as a country. So he served his time, 2 years in prison for killing, came out, and then he married the victim. So is that good for us? Is that good for our country? The country needs to move on. Does present punishment cancel past wrongs? Are we really interested in punishment for the sake of punishment? Even if we talk about all these things about trying to prevent and all that, but is it worth it? The challenge is this: the trials do not attend the psychological needs of the individuals. Trials by themselves do not promote direct reconciliation. Victims testify, but then when they testify, they must be subjected to harsh cross-examination. The design of the courts is adversarial in nature, and so it's really always me against you, always two sides. Evidentiary rules that are there, and you've studied all these rules of evidence, it means that not every kind of truth will be brought in. So at some point, the truth might not be known as it ought to. Additionally, trials can be unfeasible. So sometimes in post-conflict situations, you don't have the people. And that is the argument that Kagame was making when he established the Gashasha courts. He was saying, look, we don't have these people. We don't have judges. We don't have lawyers. We don't have the ability to continue. We need trials are unfeasible in our country. We need another thing that will help us to move on. The government lacked legal jurisdiction over the perpetrators. Trials serve as courts of the victors. And this is something we've seen from the Nuremberg trials. Tribunals are always there to charge the people who lost in the war. Tribunals remove justice concerns from local jurisdictions and disrupt more traditional frameworks for post-colonial reconciliation. International indictments stifle domestic peace. So justice versus peace. We are going back to post-election violence in Kenya, 2007. Should we pursue justice or should we ignore what is happening and get peace? Is the pursuit of justice going to affect our peace? So that we just say, let bygones be bygones and close everything? Or is our failure to pursue justice going to affect the peace that we claim that we have? So that what we have is just a cover-up. It's not really peace. If you really dig a little bit deeper, you'll see that it's still oozing out. The wound has not healed yet. So people say that if you go for indictments, and remember the people who are being indicted are people with a lot of sway in the countries, they still have a lot of following, you're going to actually affect the peace process. Okay. Then the case law of the tribunals codifies a body of precedent that systematically criminalizes the actions of less technologically advanced actors while providing exceptions for the targeted killing of the most sophisticated military. This is related to to number 9. The court is a court of the victors, not a court of the people who lost. The other bit is going for restorative justice, where you're not really looking to punish. You're saying, let's get a program that will give us a new paradigm, a new pattern of thinking. We are thinking about crime, we're thinking about justice, we're thinking about the problems that we have. We're thinking, let's start again. So unlike the retributive system, which defines crime as breaking the law or an offense against the state, restorative justice views crime as a violation of people and relationships, which creates the need that must be met. Restorative justice recognizes that crime creates needs for the victims, needs for the community, and needs for the offender. So here in restorative justice, in fact, there's a lot of emphasis on the victim, or what some people would call the survivor. How can you help the survivor to go back, to move on, to live with their lives? So that's how restorative justice looks at it. Whereas retributive justice, how can you get this perpetrator and punish him so that he doesn't repeat what he did? So restorative justice, however, can also be abused, especially where the state controls how it is dispensed. So for example, the Rwanda government exploited the traditional system of justice for political purposes, using it to dole out favors and to extract acquiescence from a terrified population. So one could argue that it was not the solution that the people of Rwanda wanted, that the victims wanted, but it was forced on them. They were told, this is what we are going to do. This is what you are going to do in terms of moving forward. You have to take it or you leave it. So the people just took half a loaf, whereas they wanted the full loaf. Contrary to popular perception, restorative justice is not a program, but a new paradigm or pattern of thinking about crime. Unlike retributive justice, I think I've already mentioned this, it looks at crime as a violation of the people. Sorry, I think I've mentioned that style. Now, what's the benefit of restorative justice? The whole idea is really to give information, whereas retributive justice tribunals help you to punish. Restorative justice helps you to get information. You want to know what happened. You want to know why it happened. You want to find out what you can do to prevent it from happening. So it's more systematic in nature. Victims see crime as an attack on self and feel personally violated. So you need to talk to the victims. Sometimes there's a need for validation, for significance, for meaning about the crime. And sometimes the healing comes in the talking. So you break the silence, you talk about it, we acknowledge the pain that you've suffered, and we then say, we are very sorry about what happened, and we assist you to move on in terms of we give you some reparations, we give you some payment, some money that will help you to move on with life. There's also the need for safety. Will it happen again? Am I safe? Will they be back again? And when will they be back? Need for restitution, need for compensation, all these things. So restorative justice helps in this recognition of the wrong victims, of the wrong that the victims went through. Now, this is very important, that the victim should be told that, yes, what happened was wrong. Okay, truth-telling. And that's why you then come and get things like the Truth, Justice, and Reconciliation Commissions as a form of restorative justice. So justice here is done when the crimes, when the needs that are created by the crimes are addressed. That's a perspective. What is justice? Justice is when the perpetrator is convicted and charged. That's the perspective of retributive justice. In restorative justice, the perspective is that justice is when the need that is there is addressed. So the victim perhaps is taken back to school. The victim goes through some form of counseling. The victim is given some money, maybe to start business so that they can move on with their lives. If you can assist the victim to move on, to go where they were, or even better, then you've actually assisted in justice. Whether or not the perpetrators have been arrested. There's a time we were doing some project in Mathare on post-election violence, and the people who raped those ladies were police officers. The problem is you cannot identify the police officer because, first of all, they did not come from the locality. Secondly, they had their uniform. Thirdly, they had their helmets. So you do not know who did it. So you cannot be stuck there and say, we want to get these people arrested. Now, I've seen some people saying the police commissioner should be arrested and all those things. But at the end of the day, people need to move on and live their lives. So perpetrators, sometimes it's almost impossible to get them. The individual who raped person X, sometimes it's very difficult to get that. So restorative justice helps moving. So the goal is to invite participation and consensus. The goal is to heal what has been broken. The goal is to seek full and direct accountability. The goal is to reunite. The goal is to strengthen the community as much as possible. So here are the types of restorative justice mechanisms. So there's mediation, which, by the way, you know, the court is...
You are muted, sir, or is it from my end?
Yeah, he's muted.
Hello, can you hear me now?
Yeah, sure.
Yes, you can.
Hello, can you hear me?
Yes, you can, sir.
Yeah.
Proceed.
Hello?
We
Yes, we
can
can
hear
now.
you.
Hello, can you hear me now?
Yes, you
Hello?
can.
Can hear you.
Yeah, where did you... Sorry. So I was saying the challenges that are there when you're dealing with restorative justice is, what do you do with the victims? How do you define victims? Okay, I apologize. Sorry, I didn't see that I was muted. Okay, so how do you deal with the victims? Who are the victims? Are the victims the people who were killed only, or victims include other people who are harmed? If you're displaced, are you a victim? Definitely you are. What about the people who saw, witnessed? Are those victims? Definitely they are. But so what? How do you stop? Where do you stop? Almost everybody is a victim if you actually take that route. So who are the people to be paid? Who are the people to be compensated? Should their surviving families, friends, and communities be included in that? They are also victims, definitely. So if you're not killed, but your family was killed, your child was killed, your father was killed, your mother was killed, your friend was killed, but you cannot pay everyone. So where does it stop? Again, like in retributive justice, where do you start and where do you stop? In terms of the relations, but also in terms of the time frame. When did the war start? When did the war end? But also the other victims, even after the war has ended. So are those who witnessed the genocide victims? How can all the victims be identified? How can you recognize all the victims? And are they all entitled to reparations? Ideally, they should. But how? You cannot pay everyone. How can adequate reparations be made when the country, like Rwanda, is bankrupt, starting again? How do you pay reparations? What about reparations for people who have been displaced and are not in the country? They are refugees. They are in exile. What do you do with them? Okay. What about women and children? Okay, those are persons with vulnerabilities. I could include women, children, persons with disabilities. Okay, do they require special reparation measures for them? Because they have suffered definitely more than the men have, I'd imagine. So what do you include? Do you give the women and children a little bit more when you're giving them reparation? Is it better to provide collective reparations, relying more on rehabilitation, rather than individual reparation? So you say, as a community, we are going to give you a counselor who's going to see you and talk to you and assist you to move. Anyone who wants can come and see this counselor and get a little bit of assistance. Or do we identify the individuals and then we say, this counselor should be able to meet the needs of person X, person Y, person Z who are victims? What are the satisfaction measures? And what are the guarantees of non-repetition for the communities? In other words, if you're giving it to the community, you then have to be very careful because people will take advantage. So do you do that, or do you give it to an individual and then you say, I have dealt with individual X, form reparation has been done? How can collective harm and individual harm be balanced? The community has suffered, the individual has suffered. And how do you then make reparations for the community and for the individual? So all these are difficult questions that we have to grapple with. I don't have the answers to them. Perhaps you have ideas. I will not take your ideas, just hold on a little bit so that you can look at TRC as a form of restorative justice. Okay, truth and reconciliation commissions. I'm sure you know about the Kenyan one. So this is there's a tribunals, we've looked at them, we've run through them, all of them. Another option is to say, let's not do tribunals, let's do TRC, Truth Reconciliation Commission. Another option is to say, let's do both of them. Sierra Leone did both of them. So truth and reconciliation have become a primary post-conflict response to mass human rights violation and are growing in prevalence in conjunction with the war crimes trials and tribunals. Now, TRC became very popular after the South African one. I'm sure you know about that. After the end of apartheid and the South African one, and what then happened is, of course, it was chaired by Desmond Tutu, who had was known internationally. But more importantly, the things that were said there, how people were broken, and how it was really very strong, and it touched the entire world. And after that, people started saying, let's take the TRC way. However, even in South Africa, there's a question of whether TRC actually worked. At that time, it really helped in terms of getting people to speak out, say the things that they did, okay, in return for amnesty. Okay, and I'd really encourage you, there are very many videos on YouTube on what happened at that time. And you can see Desmond Tutu breaking down, you can see Winnie Mandela confessing to some of the crimes that they did. You can see some of the people in the apartheid government, how they planned, all confessing to it. Whereas if we had had a tribunal, all of them would have denied all those things, and you'd never have known the truth, perhaps. Perhaps they would have got acquitted. But TRC helped us in terms of now we have that in history, in our record books. We know what part of what happened. You know what the ANC government did. Sorry, what the apartheid government did, how they planned, the things that they did. We know what ANC also did in terms of, the plans that they made and all that to kill and everything. So it's there. It's a good historical record. However, there was the return for it is amnesty. So there's no accountability in a way. So some people are still hurt until today because they feel like they went scot-free. Nothing happened to them. They killed, they planned, they murdered, but they went scot-free. Nothing ever happened to them. Anyway, so these are investigations into past human rights abuses that offer both victims and perpetrators opportunities to give an account of their experience. So here, both victims and perpetrators are allowed to come in. You're all speaking. It's not a court. The testimonies are analyzed and presented, and the whole idea is history, to help history have an official record. As a historical picture, that an official engagement with the violent past can help social recovery. TRCs contribute to the rebuilding of damaged societies through the narrative process, and it creates a historical record. It helps repair the social relationships between the perpetrator and the victims. Now, this is on paper. In reality, whether the social relationships have been repaired between the perpetrators and the victims, say in South Africa, I'm not too sure about that. Okay. So they focus on the past. These are the elements of TRCs. They investigate abuse, they are temporary, they have official sanction, and they are created during a period of political transition. Usually at the end of a war, at the end of a form of genocide, really when you need to move on. The idea is to prevent future violence, have a record, but also prevent future violence. So it's restorative. Victims come, give their views. So I'm here. Victims' testimony is given without interruption or skepticism of cross-examination. And what does this help? This helps in catharsis, in healing, because the victim is able to speak and no one is interrupting. There's no cross-examination. You don't have to be scared. Say what you went through. Also, the perpetrators participate. They acknowledge the harms that they suffered. They ask for forgiveness, and they ask that, let's move on as a society. The victims also say what they went. They are validated. They are told what you went through was wrong. It should not have happened. You're going to go through counseling. You will heal, hopefully, through that. Kenyan experience is very strange, to be honest. After the 2002, there was a transition Kenya, there's a report of the TJRC. There's a report that was given to the government, President Kibaki, and he was told to establish a TJRC to look at the problems that were there during the Moi era and Kenyatta era. But it was shelved. Nothing happened to it. Until we got to 2007, and then, sorry, this is 2007. The post-election violence that was there, and you know what happened. The people who were not born there, I'm sure you've looked at the historical records, it's horrible. And we then had to go and get our TJRC also. But ours was never successful. I think for me, it was a failure because, first of all, there were so many, the commissioners were fighting amongst themselves. The chair of the commission, if you remember the name, was Bethel Kiplagat. Was it Bethel Kiplagat or something? I think was was supposed to be a perpetrator of an event, Wagala massacre, that took place in 1982. It was just horrible. And by the time they got their report done, and they were fighting amongst themselves, and I think one of the commissioners refused to sign, and it was never got out. But the problem is we lost the opportunity. So now when you talk about the Kenyan society and you ask about healing, we never really got the truth. You never really know, the deaths that took place during Kenyatta, during Moi's time. We don't know. All these things are mystery. We don't have a historical record of all these things. They're all rumors, innuendos, and everything. We had an opportunity to stop, look back, heal, hopefully, and then move forward. But we never took advantage of that. When we did it, it looked as if it was imposed on us. We never really accepted it. The people in power also didn't want all of the truth to come out. They were not ready. So this should have happened in 2002. But by the time we're getting to 2008, some of these people in power have also committed their own offenses. So they're also they're not very clean. But also some of the people in government in 2002, remember, are some of the people who are in the Moi government and in the Kenyatta government. So they also have their own skeletons, and they don't want those skeletons to come out. So ours was very messy, and we never got what we needed. And of course, after that, we then had, together with that, we had the people who were tried at The Hague, and we all know how that got messed up, and one got convicted. So sometimes you ask yourself, so if someone got convicted, or if we had trials, do you think we would have had all this violence that we had in 2017? Again, repeated. And each time there's an election, we are always scared, or is there going to be violence or not? Because we never really healed. Anyway, let's move. Let me stop there. Talk too much. Any issues, any concerns, any questions on restorative justice? Yes, Wanyuki.
Can I comment and put spanner in the works?
Please do. Like that. Yeah.
So what? First of all, I think restorative justice is a good thing. I would look at it as a social form of justice. That there is a really no one to really blame, but what happened is was unavoidable. I mean, would have happened, and so as a society, and that is why the Gacaca courts in Rwanda, I think, have been successful because of the infusion of the traditional justice systems, the social justice system, and the fact that the most of the victims did not have the power to engage in expensive litigation. Yeah. Now, when you come to the TRCs, I think they are an elitist way of patting ourselves on the back. When you look at the people who appear on the Truth, Justice, and TRCs, it's literally people who can argue. Me and you, and the other one who can waste time to go and argue. But what does it do to the local person who has been offended there? That person at the bottom. What we want is to move on, to sort out the mess and to move on. The argument as to I did this, you did that. But since I did this and you did that, can we call it a truce? So that's why I probably maybe call it an elitist way of patting the actors on the back. Yeah. When you come to the Kenyan experience, I think most of where it has worked, the social fabric had been broken. I don't think we reached there with in our Kenyan experience. The social fabric really wasn't broken. And that is why the actors are still the same actors that we have even now. What we pray is that, maybe we have learned a thing or two from the past, and we shall never allow the social fabric to collapse so that we never end up getting into one of these. That's my contribution.
Yeah. Thanks, Wanyoike. So Wanyoike is almost saying that a precondition for it to succeed is that the social fabric must be broken down. So you must totally break down the social fabric so that you're rebuilding again from the beginning, from scratch. Very interesting thought. Yeah, and remember, TRCs were there. Even if you look at the history, there have been always, especially in Latin America, but they've never really been effective. And part of it is that the players, it's the same problem we have in Kenya. The political players are still the same. They're still in power and they hold sway. Okay, thanks, Wanyoike, for that. Any other thoughts from anyone? Before we close. Thoughts on TRC, Kenya? Al-Bashir, I don't know if that's a previous hand or it's a current hand. Okay, so I think we will stop there. Thank you very much for your time. We will stop there, and just to say that this is the last class. I think we will start your exams next week. Yeah, so I'd like to wish you all the best in your exams. I think, I'm not too sure if there's any question, general question in relation to procedures or anything like that, logistics or anything like that. I think you understand how to register and everything. So I'd like to wish you all the best in your exams. I'd like to thank you also for the time in the semester. I know I've enjoyed myself teaching you. Yeah, so I hope we get some time. If you can, like I said, kindly prepare yourself and go to Rwanda and look at what happened there. And the genocide is just next door. So it's an easy way for you to now get to see really what genocide means and how they try to resolve it. And you can then do your own research and see how it has been resolved, whether it has been resolved at all. Yeah, so I think that's it. Thank you very much for your time this semester. So I think the only thing is just for the exam during the time. I'm not sure which date it is, but just wish you all the best in the exam. Yeah. Any question? Anyone? I think your marks, your coursework marks are really based on your presentations. So that's where you get your coursework marks. Anyone with any issue, any question before we leave?